Good afternoon, everyone. I apologize for our little bit of a late start. I was down in Senate Judiciary presenting a bill, so I took a little longer than I expected. But we're going to go ahead and call the Public Safety and Homeland Security meeting to order, and I will ask Chairman Werkheiser if he'll open us up in a word of prayer. Chairman Werkheiser.
Thank you, Father. We thank you for this opportunity to come together. We pray that as we deliberate that we would use wisdom, justice, and moderation. And we thank you for everything you've provided for us. In Jesus' name we pray. Amen.
Thank you very much. All right, I'm going to get right into it. We're going to start with Senate Bill 56. Senator Anavitarte. The floor is yours, sir.
Thank you, Mr. Chairman, committee. Great to be with y'all today. Good timing having Whip Roberts in here too while we're doing this bill. Senate Bill 56, it's relatively a straightforward bill. Basically, this bill is addressing COVID-19 indemnification fund claims that were denied to fallen law enforcement officers during the pandemic. This bill basically allows families who had filed claims and were denied claims to receive those benefits. Working with the administration and the department, we know of about 29 families that had claims denied. And basically this bill is basically saying that during the pandemic up to the expiration of the state of emergency, if you were an individual that served in the line of duty and passed away because of a COVID-19 diagnosis, that you would basically be allowed to apply. In the bill, it has a very stringent window of time. So let me look here. Basically, the death would have to have occurred on or before April 15th of 2022, which was the state of emergency. And the effective date for application for your claim, for the claim, would have to take place before August 1st of 2025, which basically would allow for a 30-day window roughly when this bill goes into law. The funds related to the fund were placed in the amended budget by the House and the Senate of a tune of about $4.3 million. So I want to thank you all for your collaboration and the work that Representative Joseph Gullett did. And I do want to recognize my Senate colleague, Randy Robertson, for his help working on this bill and the folks that he represents in the public safety community, along with many of you all to see this happen. So the funds have already been approved and voted on and signed into law, and basically this bill creates the trigger in order to allow the families to apply during that very minimal window of time when that happens. Thank you, Mr. Chairman.
All right. Thank you very much. I don't know if we have any questions from the committee, but I just want to thank you for bringing this bill. One of my best friends, he was actually my partner. We were detectives with the Henry County Police Department. He was still there in December of 2020. He's 46 years old, got COVID, had a heart attack, and died. And it was directly related to COVID. And so he's probably on that list there. So thank you very much for this legislation. Do we have any questions from the committee?
Yeah, so the Department of Administrative Services, based on the research we did last year when this bill wasn't called up on sine die, and we went and revisited the numbers, and basically the claims cost would be around $4.35 million, and that amount of money has already been voted on and approved and is in the FY amended budget that we just passed a few weeks ago by the House and the Senate, and the governor signed.
All right, Representative Jackson.
Thank you, Mr. Chairman. Thank you, Senator, for bringing this bill. I don't know if I heard it or not, but when did you say the effective date that people could start applying?
It should be in here somewhere, but it's July 1st, 2025. So basically when the bill would go into law, they could start applying, and the expiration is August 1st.
Thank you.
Thank you for the question.
All right, thank you. Representative Cummings.
Thank you, Chair. Thank you for bringing this bill. I'm wondering,
Hey. Get to the mic.
I'm wondering, paragraph 55 says that the surviving spouse has to be unremarried. Why does that matter?
So my understanding is basically it's going directly to the family who would be qualified, and that's already in the statute and under the Department of Administrative Services rules. So we're not changing anything that's already been in statute already.
Okay, thank you.
Thank you.
Okay, any other questions from members of the committee? All right. We have a motion do pass. Is there a second? You're correct. Thank you for correcting me.
You can make a motion to suspend the hearing only?
Well, yeah, we are going to come back and do this very soon. We are doing hearings now to try to get through these, get all the information in. We'll have a meeting very shortly to follow up and get these passed out. But thank you for that correction, Chairman Werkheiser. I got so excited about it, I wanted to pass it today.
I get excited too.
Thank you very much for this, and I'll have you back very soon, and we'll get it passed out.
All right.
Thank you.
Thank you. Thank you, Chairman. See y'all.
All right, Senate Bill 99, Whip Robertson.
Thank you, Mr. Chairman. Appreciate the hearing here today, and due to a lot of back and forth, I will be presenting off, if you'll correct me if I'm wrong, LC 394740S.
Yes, sir, that is correct.
Right. What this started out as is a simple bill to clarify the definition of law enforcement officer in the code. It has gotten a little more complicated than that because of some confusion and differences of opinion with our friends over at, I guess they pronounce it GACTL, the Georgia Association of Criminal Defense Lawyers. And so we're working on some things, but basically what this legislation does is define law enforcement officer in order to include our federal partners when they're in the state of Georgia, assisting law enforcement agencies, and also when they are in situations where they are needed to react and cannot react under current law without the possibility of being held liable for any injuries or actions that may be determined or misunderstood by local prosecutors. This also helps with the appointments of new police chiefs. A lot of agencies, when they hire new police chiefs, they go outside the state and they hire these individuals in, and this gives these chiefs, while they're going through, a lot of times it's a brief training, I'm sure the chairman's aware of it, that their post-certification from another state comes in with them. It meets a lot of the obligations that Georgia Post does, but there is usually a small gap based on Georgia law and other policies in Georgia. And so it also identifies those individuals as law enforcement officers as they go through that training. And the bill is very straightforward, and I will, with me is Attorney Lance LaRusso, who has also been working on this legislation with the other parties and is able to testify and speak to any questions that the committee may have. And with that, I would stand for any questions.
Okay, we've got a couple of questions. Real quick, Lance, did you have anything you wanted to say to begin with, or you just want to stand for questions?
Very briefly, I'm standing in kind of a unique position here. I've been an attorney for 25 years, and I've been a certified peace officer in the state of Georgia since 1989. I look at some of the people in the gallery. I don't know if some people were here in 1989. I'm old. So I've been dealing with this issue and wrestling with some of these issues for a long time. Georgia did not have a definition of law enforcement officer, and over the years that reciprocity situation has come into a lot of scrutiny because of the delay. Post has worked very hard. As a matter of fact, I was just speaking to Chris Harvey, the executive director at Post today, and there was a need and a desire to find a way for peace officers from other states to be able to come here and transition easier. The post created an exemption test, and then they created a class, and now, fortunately, we have a lot of people who want to police in nice weather, and we have a lot of people coming that they're backed up. So when those officers are coming here from Michigan and other cold places, and they decide to work here, they have to go through their on-the-job training, their FTO, in addition to chiefs and other officers. So this gives them an opportunity to start working and be able to act and make an arrest with the Fourth Amendment guidelines and things like that that they're familiar with already. The issue of the federal officers has come up, and we tried to draft this as narrowly as we could. The Georgia Association of Chiefs of Police, the Georgia Sheriff's Association approves this. We also consulted with PAC. They're taking a neutral position on it because it really doesn't affect them very much. If you look at 17420, there's a section in 17420 that states a law enforcement officer can make an arrest with or without a warrant. That statute, that section is without definition, so it is up to interpretation as to what a law enforcement officer is. So the simplest way to resolve this to allow federal partners who are in a situation where they either witness or are assisting law enforcement officers to make that arrest would be to define law enforcement officer in Title 16 and narrowly allow that law enforcement officer definition to apply just in that one section of 17420. It does not give federal law enforcement officers the ability to go get search warrants and do first-party investigations. That is governed by Title 17 criminal procedure, which essentially says peace officers, Georgia peace officers can do that. We're not changing the definition of a peace officer in Georgia.
Okay, thank you.
Yes,
Chairman
sir.
Hitchens.
I think it's Saints.
It's me. Thank you all for the bill. So, and I appreciate the clarification that we're not changing the definition of peace officer versus law enforcement officer. My question, starting in line 32, the federal law enforcement officer section. So, the way I understand it, and correct me if I'm wrong, you mentioned how a law enforcement officer would transition to a local department now. It's a test, or is it now a class?
It's a class, and there's some tests involved.
Okay. How long is that class?
I'd have to check. I think it's 30 or 40 hours. It's abbreviated, but it hits all the high points as to high liability areas as what they have to do.
So it's a relatively short class.
Yes,
my
sir.
question, but I understand it covers Georgia-specific law to ensure that there's a standard of understanding to the powers we're giving to these individuals. A federal officer, by nature of their training, and we have a great one right north of my district, the FLETC is right above it. They don't receive any state training on state laws or regulations. Is that correct?
Not in their basic academy. If they're assigned to the jurisdiction, generally they'll get an update from their counsel. All of the federal agencies, including the uniformed federal officers, which a lot of people don't realize. You drive by the FBI office, those are uniformed federal officers that are working the gates. They will get a briefing from their counsel as to the state specific that they're in, and if they move to another state, they get a similar briefing. But it's just basically on what constitutes the difference, if you will, between a first-degree assault and an aggravated assault, or what constitutes mayhem versus disorderly conduct. There's not a dime's worth of difference between state criminal laws, except for the names and the elements, but the laws of arrest are the same.
All right. I appreciate it.
Thank you, sir.
All right. Representative Panich.
Over here. Thank you. And we spoke about this before the hearing started, and I know we're going to continue to speak about this after, but I want to make sure I understand. This is for federal law enforcement who happen to be assisting a task force or assisting a local agency with an arrest or a search warrant, or some federal officer who happens to come upon a crime that is being committed that there's just not enough time to wait for local law enforcement to get there. Is that right?
Correct. Under federal law, they have the authority to make an arrest for federal crimes that they witness or crimes of violence. So if a federal officer is standing there and somebody is actively shooting at someone, they can make an arrest irrespective of this bill. But this would allow them to make arrests for, say, somebody who is assaulting an officer and they just happen to witness it.
Okay, so what prevents them from now starting their own first-party investigation? Is there some language in the statute or in this definition that would prevent them from taking it upon themselves to go get a search warrant, from from investigating local agencies without the permission of their own agency. I mean, that's my concern, is that federal overreach into state matters. And I'm
So
curious how that is resolved in your bill.
So first of all, with regard to search warrants, if you look at the statute on search warrants, peace officers can obtain search warrants. A private citizen cannot. In addition, if a private citizen, as not a peace officer, is trying to obtain an arrest warrant, they have to go to a magistrate under the, or a Superior Court judge, but they would have to go through the peace officer, the private citizen's arrest warrant application. There's a probable cause hearing prior to that arrest warrant being issued. By not changing the definition of a peace officer, those law enforcement, those federal law enforcement officers cannot go take search warrants and go take arrest warrants, because we're not touching the definition of a peace officer. That was a concern that was raised when we were looking at this. It's essentially for them to be able to act to protect public safety and also protect their local partners.
Can it be clear that they are not peace officers, or maybe it is in the language, but if it is, can you direct me to that or show it to me so I can?
In
satisfy myself?
16.1.3, peace officer is defined in a separate section. Peace officer is also defined in the Post Act, which is at 35.1.8, somewhere around there. I'm sorry, I don't have that, but peace officer is defined, but law enforcement officer is not. A peace officer is defined in Georgia law in several different places, specifically the Post Act, with the training they have to have, what they have to have annually, the 20 hours that they have to have. And in addition, that peace officer is a certification in the state of Georgia. Those law enforcement officers would not be certified peace officers unless they went through the post training.
Thank you.
Yes, ma'am.
All right, Chairman Jaspers.
Thank you, Mr. Chairman. Just learning about this. So I think Representative Saines asked the same question I did, but I just want to make sure I understand that this does ensure that an outside law enforcement agent that comes to work in our state knows the rules.
Yes, sir.
And is that done online or through Gypstick? Or I guess because my concern is to make sure that the rules are the same that they're getting.
All of the training is done through Gypstick. All the training goes through there. The vast majority of it is done in person at the regional academies or can be done at Gypstick, but that doesn't say that there can't be certain aspects of it that could be online. Some of the constitutional law, Georgia constitutional law type questions and things of that nature. So it'd be a combination of both, but Post certifies the training, and the vast majority of the training is done through Gypstick at the Georgia Public Safety Training Center there in Forsyth.
And so they have to check that box before they could do what's within this bill. Is that not true?
If you're looking, that section you're just talking about is the police chiefs and folks like that we bring in. We identify them as law enforcement officers, but they do have to complete the training. Yes, sir.
Okay. Thank you.
All right, Representative Neal.
Thank you to the chair. Thank you to the author. We had another version of this bill in Judy non-civil, and I just want to raise some of the similar issues that came up in that committee, came up with individuals just now. And I want to start with law enforcement officer. So it is defined already in our code 35.1.7, but this allows for us to add the federal agents to what we already have. And what I'm finding is I would worry about overreach, like one of my colleagues has mentioned, because I feel like there's a lot of unintended consequences. I do like that we do have some component of trying to give them a little bit of training. But I raised this question before in the past. And when I got the list of training in reference to the federal entities, we found that, especially with Georgia going up to 800 plus hours, other federal agencies have a lot less training than us, such as criminal investigator federal training program, federal uniform police training program, land management police training, basic immigration enforcement, basic deputy United States Marshal. A number of these entities have a lot less training than Georgia is going to be allocating for. So my first issue is, granted, we are trying to give in this bill a couple hours of training, but when we have a higher bar for our officers that we're not requiring for the federal agents, that's one concern. I have a number of other concerns, but if you want to talk to that
I can
one
address
first.
that pretty quickly. So the basic law enforcement, if you will, the component for the basic law enforcement officer, those uniformed federal officers, that training class is 520 hours. It's 13 weeks. At a minimum, it's 520 hours. Up until January of this year, that was 120 hours more than law enforcement peace officers were required to get in the state of Georgia. Now we've gone to 800 hours, but they have been for years getting 120 hours more. The 1811 investigators, the federal agents that we're talking about here, they have about 6 months worth of training. In addition, their training is very unique in the fact that at the Federal Law Enforcement Training Center, when a criminal law, criminal procedure, Fourth Amendment, search and seizure, all of that is covered, the coordinator of the class steps out, introduces a federal appointed attorney with law enforcement experience who teaches those classes. The classes that are taught in the Peace Officer Standards and Training mandate class, because I've been teaching them for close to 30 years, is taught by volunteers that come in very, very rarely, unless I come in or somebody else comes in. It's not taught by attorneys. So the level of training that they receive on the federal level is much higher. I've taught at FLETC several times. I've met a lot of those folks. They have an entire training division made up of attorneys who teach these classes. So the level of training they receive, and when you're talking about making an arrest, the decision to form probable cause or reasonable articulable suspicion is covered in the Fourth Amendment seizure classes. So, like as I stated, the particular crime you're arresting someone for, whether it's domestic violence or whether it's family violence, how you term that in this state or another state changes very little, but the requirements of probable cause are the same because they stem from the Fourth Amendment.
Thank you.
And I want to be clear on one thing. We can't confuse line 20 with line 32 and what we're talking about there. Line 20, where you're talking about the gap training that would be offered to a chief coming from Iowa to Georgia to be.
Understood.
And then when we come down to 32, what we are not trying to do is thanks to posse comitatus and other things, what we cannot do is we cannot empower federal law enforcement officers to be peace officers in Georgia. The only people that can empower peace officers in Georgia is a Peace Officer Standards and Training Council. And they would have to be employed by an agency within the state of Georgia, because as you know, we can take our post-certification and go from agency to agency in Georgia if they choose to hire us. If we take our post-certification and go to Florida, they will hire us, but we will have to take that gap training, which is primarily focused on the difference between Florida law and Georgia law. So, yes, ma'am.
And I wanted to verify, the 3517 has to do with emergencies and bringing officers in from everywhere. The hurricane, where you need people to do everything from direct traffic to find bodies. So that's a part of the Post Act.
Yes, so I think, so yes, clarification for the committee. So the federal agents are not going to be doing the gap training, correct? That's not for them, that's for the chiefs.
Correct, yes, ma'am. Yes, ma'am.
So that actually, I don't know if that doesn't make it any better, only because there are a lot of, federal or not, they don't go through Georgia training, period. A lot of them don't even know Georgia-specific laws. And so we're going to have another issue that I found is, one, are they going to now be able to take part-time jobs and community jobs where, officers are like manning apartments, you name it. Are they going to take those opportunities away from Georgia, underpaid Georgia officers who rely on that type of work by us giving them this power to arrest across the state?
The average law enforcement officer on a federal level who's an 1811 federal investigator after 3 or 4 years is making well excess of $100,000. I cannot imagine them wanting to work a part-time job.
But to your question specifically, they would not be qualified to take that job because they do not have arrest powers where they could arrest somebody on there working as, they would have to be sponsored by a local agency to even begin to do that. And when I say sponsored, I think the lady understands the process as well as anybody. They have to be deputized, basically, to do that. And then we move into the task force possibility of that, and they already have the ability to come in and be sworn under the task force model and go out and assist local law enforcement agencies in enforcement of certain laws.
So that goes to my next two questions. The first one is, usually, yes, if you're going to work across the state, you have to be deputized. And how and who would deputize them in this instance? Is this bill removing the requirement to be deputized?
Not at all.
So then who would do it for these entities and do it in time for them to be able to affect this bill?
They would not be deputized. No, ma'am. All this does is recognize what a law enforcement officer is if they have to go out and take an action. And this, in the cases we're talking about where I think there was some concern, is if one of these federal law enforcement officers witnesses a crime occurring, they witness a municipal police officer being attacked, and they wanted to respond, what it would do, they would be identified as law enforcement officers in those actions. Therefore, they would receive the same type of protection from criminal prosecution should they have to use whatever level of force necessary. They are not, the deputized part, that comes in on any federal task force or any local task force that decides to bring federal resources into it, because they would still have to be deputized because their federal certification would not be applicable.
Right, so I think that's where it gets a little foggy.
How about I suggest that this is a hearing only, so I'm going to let y'all
Okay.
continue that offline if you don't mind, just so we can move on.
Okay.
I understand your concerns. I think you're misunderstanding what they're trying to do here.
No, like I support the initiative,
And
but
they
I think there's so many unintended consequences, like who handles paperwork, who files
There's
it?
there's no paperwork. They're not making the arrest. It simply allows them to act in place of the citizens arrest law that was taken, that we did away with, and this allows them some protections to act in a immediately necessary position, and have protections of a law enforcement officer. We're not giving them arrest powers and things like that to go across the state enforcing state law. So, all right, we'll come back. Stephen Sainz.
Thank you, Mr. Chairman. Just a follow-up. I believe you mentioned something about a specific class of law enforcement officer. I just want to clarify for the record, this is all law enforcement officers we're giving this power to, or privilege, whatever you'd like to call it, correct?
Yes, sir. If you can ask something more specific, I might be able to.
You mentioned something about federal investigators. They receive a set amount of training, 6 months. This is, just for clarification, all sworn federal officers,
Yes,
correct?
and that's why we put the definition in under line 32, but we also, and not to be indelicate about it, but just because you call yourself a federal officer doesn't mean you have the training necessary to qualify under this bill. So these are officers who are sworn, they're sworn to carry firearms, they're authorized to carry firearms, and they have the necessary requisite training. We don't want a clerk who happens to work with a federal agency that has some administrative authority to fill out paperwork to qualify.
No,
under
but
this.
it would include, for example, National Park Service, Cumberland, and law enforcement officers.
Yes, sir, if they're law enforcement under
Yeah,
federal.
if they're carrying a gun with
Yes,
a
sir.
badge on a federal.
That's generally that's the defining line in federal.
Question to the majority whip, Senate Majority Whip. You mentioned something to the effect of there's questions back and forth on the training element, and this is sincere. I forgive my ignorance, but is this bill a measure to avoid that that training, that I think you said 30, 40-hour training? If we did not do this bill, could an agent go and do that? You mentioned something to the effect of they couldn't do that training anyways, they couldn't be deputized.
No, what I was talking about is, and I think where we got to is there's been a little bit of confusion between what starts on line 32 and what starts on line 20. Where line 20 defines those individuals who are peace officers, as you and I have been, if they decide to move out of state and move into Georgia and want to become a peace officer or a police chief. Then if they're hired as a police chief, they would have to go through that familiarization gap training in order to qualify them with Georgia Post. That's with those. With the federal side, they are not required to get the training to act, as the chairman spoke. What it does, it gives them protection to act. If I'm in the parking lot as a Georgia peace officer and I'm engaged in a confrontation with somebody, this federal officer pulls in there on his way or her way home from work, then they would come up and I've had to do this myself here in the city of Atlanta, where they would identify themselves to me. Hey, I'm John Smith with the Federal Bureau of Investigation. Do you mind if I assist you in this arrest? And I would say, no, I do not. And while we're making the arrest, the individual is injured somehow by a handcuff or whatever, and that individual would have the same protections that I would have. They would, in other words, my qualified immunity would be mine, but they cannot be arrested for assault.
I appreciate that context and ensuring they have the liability protections, but is that the public interest we're discussing? What is my question, I guess, is right now, without passing this bill, what is there a way to attain this same protection through training, through state training of any kind? And if not, what is the restrictions currently in place because of our citizens arrest law, I guess, is the reason we're bringing forward?
The restrictions currently in place is any federal law enforcement officer in the state of Georgia could not assist in police actions without exposing themselves to Georgia criminal law and civil liability, is the way I view it.
And are they currently not assisting in police actions due to this?
They avoid it. They have had to avoid it with things that have occurred with inside the Beltline here in Atlanta and in other places. While they wanted to, all they could offer was making a call on 911.
Thank you.
Yes, sir.
All right, that looks like all the questions that we currently have from the committee. And I'm going to again encourage Representative Neal to speak with them offline, and you and I can speak about it as well. And I see Representative Reeves back there who had a similar bill on the House side that I'm sure he can help answer some of those questions for you. So, all right, Will Robertson, thank you very much. Oh, I'm sorry. Well, Lance, we've already got you. I had you down here to speak, and
Yes,
you've already
thank you,
spoken. Maisie Lynn Girton from Gactal, there she is.
You got it back right. You got it right.
Yeah.
Thank you, Chairman and committee. So our concerns are not in the definitions that you all have been discussing at length here today. Our concerns are with, I'm sorry, I thought I did.
I didn't hear it.
I'm sorry. Maisie Lynn Girton. I'm the Executive Director at the Georgia Association of Criminal Defense Lawyers. Sorry, I'm used to doing it. I must not have done it. I'm sorry, sir. So our concerns aren't with these lateral moves, but we do have a difference of opinion with Mr. LaRusso on how narrowly constructed this bill is to achieve their purposes. Essentially what's happened, as I understand it, is that when this body repealed citizen's arrest, it made it impossible for federal officers, for instance, acting on a task force in conjunction with a state agency, to make arrests, because they were leveraging the citizen's arrest power that they had prior to that repeal. In fact, last year, House Bill 1383, which is, I believe, what Representative Neal was referencing, was brought by these same agencies to repair that. At the time, we thought they were doing it in the most narrow and efficient way, my association. We took no issue with it. We didn't raise any concerns. This bill is a much more expansive way of achieving that goal, and we believe it could be more narrow. We have provided some language, though I did it without the benefit of the sub, so my line numbers are wrong. But essentially, the idea that we're suggesting is that rather than including federal agents in the Title 16 definition of a law enforcement officer, that you simply put the federal agent into the citizen's arrest law in Title 17. You can see on, I believe it's the second page of the sub, that's what's happening. They are indeed putting the definition of law enforcement officer into 17420, but only after expanding it in 1613. By expanding that definition in 1613, you are now going to apply this new set of people that we've heard today. Chairman Saines mentioned it will even include park rangers who are federally recognized as officers in the state definition of a law enforcement officer. You don't have to do that in order to cure all of the things you've heard today that are problems. All you have to do, and you had the language, well, the House had the language last year. I would be happy to provide you all a copy too, where you can put that definition into Title 17, allow them that citizen's arrest power, then you've cured those concerns. And you have not expanded it so far that you now are doing things like bringing park rangers into Title 16. For all of Title 16. For going forward from today, for everything you all ever put in Title 16 and reference a law enforcement officer, you would be putting this cohort of people into that title, when really the goal is to put them into 17-420 and give them all of those arrest powers that I don't disagree that we need. I surely would love for an agent to help me if I was a victim of assault in a parking lot and he happened to be there. I mean, that's not the issue we have. The issue is the expanded way that they are trying to achieve this by putting those officers in Title 16. I would stand for any questions that you have.
Well, I'm going to recognize Representative Neal.
Don't be so hesitant.
I am somewhat hesitant. So
Should I be?
We're trying to act with brevity here. We got a couple of more issues to hear. So
Yes, so thank you so much for the solution. I've been asking for a lot of solutions. I know I did want to say a shout out to Representative Matt Reeves, who has been working on this, and also Homeland Security, who has been in contact as well, trying to come up with a solution. I like the recommendation. I think it avoids all of the other unintended consequences, because I want this to happen too. And thinking of the easiest way to pull it off, I like this recommendation. I just wanted to make that comment, sir.
And just for clarity and transparency, we were also in conversations with Representative Reeves and with several of these law enforcement agencies on the House side. This is not the first time any of them have received this language or been informed of our concerns about the bill.
okay, thank you. I don't see any other questions.
Thank you.
Thank you. All right, as this was a hearing only, we'll Whip Robertson will have you back to at our next meeting to continue the discussion and move this bill forward. So
We'll be ready to go.
all right, thank you.
Thank you.
All right, Senator Rhett. Yes, sir.
I'd like to ask a question while the office bill is still here before Dr.
What's his number? All right, I got your mic on now, sir.
To the author of the bill, Senator Robertson, before you get away, before she gets away, do you oppose her amendment, her proposition as an easier fix for this?
Yeah, there were some problems last year. Georgia Sheriff Association, other groups opposed it because it was a much longer amendment and caused more concern for them. But again, as I said when I came in, I'm more than willing to work with members of the committee to get to where we need to be, where everybody's comfortable. Thank you.
Thank you.
Thank you for that. All right, Senator Rhett, you have the floor, sir.
Thank you, Mr. Chairman, my fellow legislators, colleagues, friends, and y'all. Here with the less complicated bill, and this one is Senate Bill 147. This legislation would allow the Georgia Department of Correction to give inmates being released documents relevant to finding work after release. Those documents include copies of the inmate's vocational training record, inmate's work record, certified copy of birth certificate, copy of their Social Security card or replacement, the inmate's resume, including any trade learned by the inmate, and the inmate's proficiency at the trade, and documentation that the inmate completed a practice job interview. The inmate would be notified that the inmate is eligible to apply for occupational license for whichever state agency oversees the licensing of the relevant trade. The Georgia Department of Correction would also provide a copy of any program and treatment completion certificate. The following inmates would not be required to if you're over 65 and you're being released or medical reprieve, you won't be charged. But the bill still also maintains a requirement passed in 2023 that the Department of Driver Services and the Georgia Department of Corrections provide identification cards or a driver's license to the inmates being released who did not have a valid state-issued ID or driver's license. And this bill was put together and written with the members within the Department of Correction. And if anybody has any question, Mr. Chairman, I'll be glad to ask and try and answer.
All right, sir. Thank you. Number 25. Chairman Petrie.
Thank you, Chairman, and thank you, Senator. I appreciate what you're trying to do here. We certainly want people to come out of prison and have second chances and immediately get back to work. I do want to call your attention to one thing that we should discuss and maybe deal with, and that is this. So as we talk about all these things we want to release people with to allow them to get back to work, we need to recognize that by federal law, inmates that are illegally in the United States cannot work. That is a civil and a criminal crime. And so we certainly want to make sure that, especially in light of what we accomplished last year, dealing with sanctuary jurisdictions and how we deal with people in jails, compelling them to work with ICE, compelling them to honor ICE detainers, we need to make sure that you have to carve that out. We certainly want to make sure. Sadly, there are a lot of individuals who are illegally in the country who have committed crimes who are in county jails, and about 1,700 today as we speak in state correctional facilities. We need to make sure that we're not encouraging them to work, because that is, by federal law, a civil and criminal crime.
I guess I forgot to mention that this bill doesn't pertain to county jails. It's just to the state prisons.
Gotcha. And I noticed on line 3 it mentions counties, so that may have thrown me off. But either way, I think that the question is the same. Again, we have 1,700 we know today just ICE detainers in our state correctional system. So we do want to make sure we're not encouraging people that shouldn't be in the country, and we should where we've compelled jails and jailers to work with ICE. Those individuals should be removed from the country, and we certainly don't want to encourage them to be working in this state. I hope you would agree with that.
We can remove county and just leave state prisons.
Okay, sir.
I'm open to that. Thank you.
We'll talk about it.
All right, thank you. Chairman Powell.
Yeah. Senator, I appreciate the bill. I'm a little bit familiar with it, as I worked with the Department of Corrections 25 years ago when they started the reentry program. And that we all knew at that time that 99% of all inmates are going to be released from prison at some point. And most of them came out at that time with nothing more than the traditional suitcase and a bus ticket. And when corrections started this, and we prompted them at that time to start doing a reentry program for inmates who were getting prep them to get out where they could get a job, and hopefully they became producing citizens at that time. But I'm looking at this. Is this being asked for by corrections?
Yes,
to make these changes?
We work together on it.
It looks like it's, the old language was about the same, except this looks like it's a little bit more, speaking of a resume and such as that, it looks like it's a little bit puffed up, and I want to be sure that they'd ask for it, because I wonder, given the other issues they're having at corrections, if they'll be able to accomplish all of this, like specific work records. You got a long-term inmate, a lot of those records may disappear and things.
Well, that's why we didn't work with the county jails. We work with the prisons because they're more, for lack of a better word, captive audience.
All right.
So you have more time to work with them. And usually what happens with this bill is if the inmate requests, then they're eligible for it, but it's not like everybody is mandatory. It's just those who have followed along and made a request to be a part of the program.
Very good.
And I work together with Rita Rocker and the members from work with the prison and Department of Driver Services.
Thank you for bringing this bill.
Yes, sir.
All right, thank you. Chairman Werkheiser.
Hey, Senator, thank you for the bill. And you and I worked last year on Senate Bill 218, I think. How's this different from that bill? It sounds like this is an expansion of that.
Yes, sir. With the one we worked on, they were eligible for a driver's license, valid driver's license, or a state ID. Well, this one's a little, help them to put together a portfolio and make them a little more prepared so that when they go outside that they can have a better chance of trying to get employment, and
Okay.
reacclimate themselves in society.
Okay, I appreciate the effort. We'll work with you on these other issues. I'll talk with you. I appreciate you working on this.
Thank you, sir.
All right, thank you, Chairman Werkheiser. All right, I don't see any other questions, sir. We'll, Chairman Werkheiser will get with you and help work on some of that, see if we can get some of these questions answered. I know Chairman Petrie had his concerns. He still has a concern about that, even with it just being state, not being county, but being state facilities as well. We want to make sure that concern is taken care of. So
I understand. Yes, sir.
Thank you, sir.
Thank you. Thank y'all.
All right, and now Senate Bill 21, Chairman Tillery. Hopefully you've caught your breath now. I apologize for you having to rush back over.
Oh, no problem at all, Mr. Chairman. Thank you so much for allowing me to get there. You know, I'm not used to my bills being heard this fast in the House, so thank you so much.
We try to accommodate, sir.
I appreciate it.
That motion's out of order.
I appreciate that from my good friend from the southeast corner of Georgia there. Senate Bill 21 aims to tag on to the good work done by the House in several bills over the past 2 years and further advance Georgia's policies on illegal immigration. I know Representative Petrie, Representative Gaines, and others have advanced this cause, and I hope this just is viewed as an assist in that approach. Senate Bill 21 says very plainly that if a city or county or other governmental entity were to have sanctuary policies, which are already outlawed in Title 36 of Georgia law, or were to not fulfill the immigration detainer orders, which are already required to be followed under Title 42 of Georgia law, then they waive their sovereign immunity for acts that may happen because they did not follow those laws. I think case in point that everyone would point to, and I hate that we always come back to this one, but it's so tragic and it's also so much relevant on people's minds, is if you look back at the incident in Athens. If Clark County were deemed to have been in violation of Georgia's immigration laws by being a sanctuary city, I know that there's a debate as to whether or not they were, or if they were to have not followed the immigration detainer order in that case, then that local government would stand responsible for the harm that befell that family because they did not follow Georgia immigration law. This bill may have gotten a lot of press and a lot of comment, but it's simple. It's actually 2 pages and 1 line. It's simple because it's direct. It aims directly at a problem. Sovereign immunity is a benefit that's given to Georgia counties and cities, and if they're not following Georgia law, I believe this is the absolute most direct path to tackling that issue head on. There have been, and I apologize, Mr. Chairman, again, not realizing this bill was today, and I want to be fair to the Georgia Municipal Association especially. They brought an amendment to me earlier today. I read it when we were sitting back there. They may speak about it. It concerns me because what it does is it says, at least my reading of it, do you have that in your file yet?
I have a copy
of it.
I have a copy. I don't think we were able to get copies to everybody on the committee, but I do have a copy they sent to me earlier today.
If you want me to wait and talk about it after they do, Mr. Chairman, I'm happy to do so. I want to follow your lead in what you
Well, if you want to, go ahead and offer your commentary on it real quick. We got several questions popping up, but then we'll get them to elaborate on it.
My reading of their proposed change would allow a local government 15 days to cure once they were adjudicated to not be following Georgia law. Georgia law is pretty clear. If you get an immigration detainer, you're supposed to follow through with that detainer. Georgia law is also very clear about its sanctuary policies. We say that you should not have sanctuary policies. So to follow the amendment that I believe will be offered by GMA and say that before a city or county could waive sovereign immunity, they would have to be adjudicated to not be following Georgia law and then have a 15-day cure clause is to give at least one free bite at the apple and potentially more if you have to be adjudicated each time to have not been following Georgia law. So I would ask you, if you want to advance the issue that the House has found very important to advance forward, I don't think that amendment helps you do so.
Okay, thank you. Chairman Petrie.
Thank you, Chairman, and thank you, Senator. I appreciate your good work here that you've worked here in. You alluded to this, but House Bill 1105 that we passed last year, 368023 and Code Section 42, you're right in there. I appreciate what you're doing. To your point, you are continuing to improve on it. I'll also tell you this. You mentioned Lake and Riley. You don't have to just pick Lake and Riley. We have today 182 murderers who are illegally in the country. We have ICE detainers in our state correctional system. We have 1,700 violent felons in our state correctional system today. So I think everyone saw in the news last week you had 2 individuals in California that had 12 ICE detainers had been denied by local government, and they were arrested for murder. So listen, it's real clear. We've made it a crime, strongly made it a crime last year with 1105, and I thank everyone in this body that helped me to do that, and I appreciate you helping us to do that. But we've made it clear that it's a crime. There's no excuse now for local government violating the law, and if they continue with this intractable desire to violate the law, as they were doing before, if they continue to violate the laws of this state, they should be held accountable. So I appreciate what you're doing, and again, to your point, I appreciate the anything additionally we can do to protect people like the victims of those 1,700 violent individuals just in our state correctional system today, not even talking about our county jails. So I appreciate the good work you're doing. Thank you.
All right. Thank you, Chairman Petrie. Chairman Powell.
Yeah. Thanks, Senator. I appreciate this. Living over next to Clark County, I'm a little bit familiar about some of their political policies over there. And I'm sure there's other places in the state. But I'm not an attorney, but if there is a governmental or if sovereign immunity is violated, what's the penalties?
In that case, so right now, using Representative Petrie's examples of the 1,700 violent crimes that were created across the nation, I don't know how many of those would impute to Georgia.
That's in Georgia.
That's in Georgia, 1,700 in Georgia. Those families, if you were a victim of one of those 1,700 perpetrators, you would have a cause of action against that local government for not enforcing Georgia's laws. Because the belief is if Georgia was enforcing those laws, those 1,700 individuals would not have been on Georgia's streets to commit that crime in the first place.
So it opens up to civil litigation.
It does. Your bill 1105 last year said that those entities, those local governments would not be eligible for state funding. This takes the next logical step of saying, hey, they can't get that fund to begin with. This opens up their pocketbook to pay for the crime, for the penalty that family had because of it.
There's nothing in this which is going to be circumvented by the tort reform bill, is it?
That bill's in the House, Mr. Chairman, so you'd have a better answer than I would.
Thanks for bringing the bill.
Yes, sir.
All right, that looks like all the questions we have from committee members for now. We do have several people wanting to speak. We will start with GMA. DJ Waller, sorry. I know your name's DJ Waller. I know. I'm trying to read it on here. And Rushi, thank you. All right, the floor is yours.
Good afternoon, everyone. Once again, I'm DJ Waller with the Georgia Municipal Association. We represent all 537 cities in the state of Georgia. I'm here with Rushi Patel, our General Counsel, for all the hard-pressing questions that will be directed towards him. So I'll start off by saying thank you to the committee. Thank you, Chairman Tiller, for listening to us, working with us. And I'll start with cities across Georgia. Appreciate the efforts of Chairman Tiller and the committee in addressing important issues through this bill, Senate Bill 21. We recognize the intent behind the bill, and we share the goal of ensuring accountability and compliance. And I will state that we do not support sanctuary policies. However, we believe a few key amendments would strengthen the bill and provide a more balanced approach for local governments, and that's what was in the handout, the one sheet that went around. One of our primary recommendations is the inclusion of a 15-day correction period, which would allow custodial authorities the opportunity to address violation before facing penalties. This amendment encourages compliance rather than immediate punishment and helps reduce the risk of costly litigation. Additionally, we support the inclusion of declaratory judgment option, which would give the city's ability to seek legal clarification before penalties are imposed, ensuring that local governments can navigate compliance with confidence. These adjustments help protect municipalities from unintended liability while still upholding the bill's intent. As I mentioned, we appreciate the opportunity to work collaboratively on this legislation and look forward to continuing our discussions on how to achieve the best outcomes for both the state and local governments. And I'll turn it over to Rushi.
Thank you, DJ. Good afternoon, everyone. So when we provided this language to you all with the declaratory judgments, this is actually something that was passed by the General Assembly just 5 years ago in a form of constitutional amendment, and it passed the voters at a 75% clip, the declaratory judgment provision. And what happened is this constitutional amendment allows anyone in the state to file suit for a declaratory judgment against local governments when the local government acts outside of the scope of lawful authority in violation of the laws of the Constitution of the state or statute or the Constitution of the United States. That's in the Constitution now. And Chairman Tillery maybe inadvertently kind of brought forth our point here is when talking about the Athens situation, and that there's a debate as to whether or not that was a sanctuary policy. And what we're seeking here is some sort of court ruling that says, hey, that is a sanctuary policy or that is not a sanctuary policy, and what is that policy? And now you have 15 days to fix it. Because in a lot of these debates and a lot of these situations, there's the word sanctuary policy, the words sanctuary policy are thrown out, but there's never actually any judgment as to what is the sanctuary policy and what is not the sanctuary policy. And what we think here would be useful would be to have some court ruling that says, okay, what you've done here is a sanctuary policy, now you better fix it. And our proposed language here says if you don't fix it within 15 days, then all those civil actions can be brought just like Chairman Tillery would like, and the local governments will pay all the attorney's fees and court costs related to that. So if we don't fix it in 15 days, we're paying for it. And so that's the suggested language that we have. And so that 15-day cure period is really to just get to the point of, is this a sanctuary policy or not? And be glad to take any questions.
Okay, you have a couple. Chairman Werkheiser.
Thank you.
There you go.
So, a little confused because, okay, so there was a debate in Athens. They said we did not have a sanctuary policy, but their actions indicated differently. So whether it was an official policy or not, they did not act. There was crimes committed. They did not follow the current law, and there was a crime committed. How do you fix within 15 days, 1 day, or 365 days if a crime is already committed? There is no corrective action on that. And let's say they were very clear they were not a sanctuary city, but yet their actions, their lack of actions, created a situation that should not have happened. The crime was committed. You can't fix that within any amount of time. Does that make sense?
It makes sense. So I would agree with you. You can't fix a terrible tragedy. A terrible tragedy happens. It happens. You don't have a time machine. You can't go back and fix it. I think the issue is that if there is a sanctuary policy or a debate as to whether there is a sanctuary policy, what are you getting off the books? The policy is usually something that it's a practice. It's something that they're doing. What are you getting off the books to stop it from happening again? And do you have a judgment that tells you what that is? Because without something pointing to what that is, what you end up having is a lawsuit and just right now we're in a year-long debate as to whether or not that is a sanctuary policy or not, even though there's a provision in the Constitution that somebody could have said, I want a declaratory judgment that the city of Athens has a sanctuary policy. And this is pointing this to them. This is saying, hey, the voters said declaratory judgments as to whether or not you are violating the law point you in this direction. Get that declaratory judgment that you are violating the law. And for some reason, that hasn't been utilized, even though it's been in the Constitution for 5 years.
Okay. Floor Leader McDonald.
Thank you, Mr. Chairman. Just like probably ACCG, they insure counties around the state. I'm sure GMA, I'm sure y'all do the same. Why would it not be the policy of GMA? I'm sure you monitor things that are going in all the cities. You've got a huge staff, and when you see these actions, when you see these words coming, whether it's from a councilman, from a mayor, why are y'all, reaching out to these municipalities says, stop using those words or we're not going to insure you? I think that's where you start. If you're worried about this bill, protect yourself from these municipalities and protect our citizens in Georgia. That's what needs to happen.
So I agree. We absolutely reach out to our cities throughout the year, especially with the immigration reporting requirements that the state has put in place for 13 years, 14 years now. We talk to our cities all the time. We provide them with the information of you cannot do this. I'll be frank, I've literally written a 100-something page book on how to follow state law on immigration policies in the state of Georgia. We have it on our website. I could be glad to share it with you. We teach our cities, do not do this, over and over again. We send them information every year. Hey, just a reminder, don't do this. And we have training
Follow up.
year, so sure.
Well, you know what I did with my children when they did something I told them not to do? I took shit from them. And that's what you need to do with these cities. If they're not going to follow your policy, you need to cut them off because all you're doing is hurting the other cities.
Okay. All right. That looks like all the questions we have for you now.
Thank you.
And just since he brought them up, Floor Leader McDonald brought up his children. One of his fine children has snuck in back there, a fine cadet at the Citadel. We're glad to have you here with us today. Larry Ramsey with ACCG.
Mr. Chairman, you have a preference here or there?
Wherever you'd like. All right. Floor is yours.
Thank you, Mr. Chairman and members of the committee. Larry Ramsey with ACCG, and I will not try to cover the same ground as my colleagues at GMA, but did want to make a couple of other comments. As several of you have pointed out during this discussion today, Senator Tillery's bill builds on House Bill 1105 that came out of this committee last year and put penalties in place. That law has been on the books for 9 months. And so one suggestion from ACCG is let's see whether that bill is effective. So I think Senator Tillery mentioned this. That imposed several other layers of penalties on local governments that either do not comply with ICE detainer requests or otherwise have sanctuary policies. And that's defined in the law. Sanctuary policy is a policy or practice that of not honoring ICE detainers or otherwise not cooperating with federal immigration officials. But the existing House Bill 1105 on the books for 9 months, if a local government does in fact have a sanctuary policy or is not honoring ICE detainers, then they lose their state funds and permits, and they're also subject to criminal penalties for the individuals that are violating those existing state law provisions. Those are pretty big sticks. And as you know, this General Assembly appropriates a lot of funds for local governments every year. LMIG, the more recent local road assistance program, a long list that Senator Tillery would know more about than I, but it goes on and on. That is a big hammer. And so we would suggest that the existing law be given time to percolate, and to the extent there's a problem, see whether that problem persists. Beyond that, if this bill is going to move forward, if it's the will of this committee, a few suggestions and issues that we would like to point out. Senator Robertson had a bill a little while ago about limiting law enforcement liability. This bill would expand law enforcement liability, particularly you think about it from the county perspective. It's the sheriff that is responsible for honoring ICE detainer requests, the policies of complying or cooperating with federal immigration officials in the county context is going to fall on the sheriff. And so when we're talking about waiving sovereign immunity and other governmental immunities, we're talking about the immunities of the sheriff and sheriff's deputies that are perhaps not, or at least arguably not working with federal immigration officials in the way that they should. Now, when it comes to the bottom line is that the county governing authorities are the ones that fund the budgets for the sheriffs, et cetera. So if there's legal liability coming from this, it's coming back to the taxpayers. But the County Board of Commissioners is not the one that has the ability to force the sheriff to comply with ICE detainer requests, for example, to the extent that that's what's going on here. So that's one issue. If the bill was going to move forward, we would ask for some clarification. We can provide language that we have drafted but not shared yet with the committee. I think we have discussed early on with the author.
Actually,
Okay.
you have.
Okay.
So we just
Okay.
passed that out. So.
Okay, very good. So one of our suggestions is to try to make it clearer than it is now under existing House Bill 1105 that the waiver of immunity would be with the local governing body. That's a defined term that's in the law right now that is actually violating the law, that waiver of immunity would not expand, for example, to the County Board of Commissioners if it was, say, the sheriff that was not complying with existing federal law. Another request that we had in this, and is likely in the document that you have, is to make clear exactly what is required for a detainer request. And I will explain why we've suggested this language. You'll see that we're asking it to be tied to a 48-hour time period on a detainer request. The reason for that is existing federal regulation that a detainer request is a request for local law enforcement to hold a detainee for up to 48 hours beyond their normal release date. So we have someone in the county jail, they're scheduled to be released from their ordinance violation, state law misdemeanor violation. That's a request to hold that person for up to 48 hours so that ICE, if it so chooses, can come pick up that person. I think we would all agree that the current administration is being much more aggressive than the previous one on immigration matters, and it's quite possible that what will be requested of local governments in the immigration space will be broader than what it has been to this point. A 48-hour time period, locking it into the state law, would protect local governments from being between a rock and a hard place, and let me tell you why. Obviously, existing law requires our counties, our cities, our local sheriffs, et cetera, to honor detainer requests. Right now, that being 48 hours, that's workable because the courts that have addressed that issue have said that's a reasonable time period in which to detain a person on probable cause, and that detainer request can constitute probable cause. If the federal government chose to expand those detainer requests, then the local government is stuck between either trying to honor state law, which might require them to hold somebody indefinitely, a week, whatever the ICE requests, and then on the flip side, getting sued by that detainee for violating their Fourth Amendment's rights for holding them beyond a reasonable time. Again, I think 48 hours, the courts have generally considered that to be a reasonable time. This is a protection, again, that we're asking for to keep the local government between. They're going to get sued from one angle or the other in that context if they're holding for a longer period. To the point that was made, the last thing I would say, we do, as Representative McDonald said, we also have an insurance pool for counties. We are often the insurer of last resort particularly in the law enforcement space. Many private insurers will not insure because of the potential liability already in the law enforcement space. This will raise costs for everyone that might be in our pool, and as the representative said, perhaps you have a particular county, for example, a particular sheriff's office, which is bundled within the county's insurance policy. Maybe you get to a point where you're having to cut someone off, right? You're terminating their policy. That's certainly not our goal. We try to make sure that we are there as the insurer of last resort for a local government that may not be able to get insurance on the private market, and this will make it harder on us to do that. So again, I thank you, Mr. Chairman and members of the committee, for letting me speak today, and I'm happy to try to answer any questions.
Okay, you got a couple. Chairman Sains?
Thank you, Mr. Chairman, and thank you to ACCG for testifying. I appreciate your mentioning of House Bill 1105, and it's been there for 9 months. But the way I understand this bill, it doesn't do anything to the effect of weakening or even messing with, for lack of a better word, the policies provisions we put in 1105. And when we talk about sovereign immunity, the king can do no wrong. We're not talking about waiving all sovereign immunity to the local government. We give this immense privilege to our local governments because we are in the understanding they are acting in the interest of their citizens. Would that not be correct?
I think that's right. It's not just the king shall do no wrong, but also a protection of the public purse. But yes, it is a privilege that the Constitution currently grants to the local governments.
Is there any public benefit for local governments acting in defiance or in ambivalence to our federal and state immigration laws?
I would agree that local governments, there is no benefit for violating law. I agree with that.
So the way I read the bill, and unless there's other clarification, and this is simply clarifying that fact that we are not going to give an immense privilege in the courts to a local government not acting in the best public interest of our citizens. And I just don't see a policy position that anyone would take that would preclude us from acting on that.
If I could just make one follow-up comment, and I appreciate your point, Representative. I think as a longtime county attorney in my previous career points, I think what we'll likely see is a fair bit. I agree, this doesn't change the substance of law. It changes the penalties that come from not following existing law in the immigration space. What I think is likely to happen is with these waiver of immunities, there will be efforts by plaintiffs' lawyers to turn everything into a sanctuary policy. So if a car wreck is caused by a person who's illegally in the country, that person's not likely, that person may be judgment proof, right? So that plaintiff's lawyer is going to be looking for someone who can maybe cover the bills and be answerable to that. So there will, again, I've seen this in other contexts, I could see a cottage industry rising that folks will be saying, look, if this local government, I think they have a policy or practice of not cooperating with federal immigration officials, and I'm going to try to sue them to try to get some recovery. Again, I know that's a slippery slope, sky is falling argument. I just think practically we will start seeing that type of lawsuit.
Okay, thank you. Representative Neal?
Yes, just had a quick question. Sorry, I stepped out. This was answered already. So just to clarify, under this bill, if an entity has to release after 48 hours, like they just cannot hold anybody any longer, can they be held liable under this current bill?
So and I'm trying to understand the question, so if you give me just a second. So under the bill as presented to you,
yes,
which builds on House Bill 1105, it is an obligation right now and would continue to be an obligation of local government to honor ICE detainer requests, period. Under current federal law, that's a request to hold somebody up to 48 hours. But this bill doesn't say that. It doesn't say that it's limited to 48 hours. If a local government does hold someone, let's say right now, if a local government, a sheriff, et cetera, held someone beyond that 48-hour request, then they're potentially exposed to lawsuits by that person who's being detained, that it's an unlawful detention, a Fourth Amendment violation. And so I don't know if that answers your question, but that's what we're trying to get at with the request about tying it to 48 hours as a reasonable time frame, and that, again, that's consistent with existing federal law.
Yeah, because the issue has always been, it always takes ICE forever to come. That's like, and so putting the putting the weight on the locals that can't control how fast it takes, ICE to come. I think that's always been what we've been battling against.
I think that's fair, Representative. And again, the ICE detainer request as it exists now is a request to hold up to 48 hours. Now, we haven't talked about, there's other law that requires local governments to pursue 287G agreements or other cooperative agreements with ICE and Department of Homeland Security that might get us into the space of then holding people as kind of being deputized by ICE to hold people longer. And so that potentially leads to litigation, and also there's cost associated with that. If you're holding more people in jails, then in many of which are overcrowded, that's an administrative and additional cost burden on those local governments.
That they don't get back from the federal government.
Not to my knowledge. I'm not an expert on 287G agreements and what compensation might be involved in that.
Okay, I think Chairman Petrie may be able to help with that a little bit.
Thank you, Chairman. I think I can clarify some of this. So first of all, by definition, an ICE hold is 48 hours. That's been upheld it's been thoroughly vetted by the federal courts. And your point is, what if it changes one day? Well, for that reason, I don't mind it being, defined, because it's, in my mind, it's already defined. Having said that, to ICE, we have administrations that have refused to pick people up from prisons, like the previous administration, with all due respect. So you are correct that ICE is not always prompt to pick people up. But what we need to state real clearly is this: a local jurisdiction that simply honors a 48 ICE hold when ICE says hold them, that's not a sanction. That means you're complying with the law. The 1105 requires that every year the local jurisdiction applies to 287G. It doesn't suggest you have to have one, but so if you're touching all the boxes, it's very clear you're not a sanctuary jurisdiction. And if you aren't, you can say, well, it's going to increase lawsuit. No, you've got no attorney is going to be able to suggest you've got a sanctuary jurisdiction when they're clearly not doing everything they can to basically avoid working with federal immigration authorities. You would have to prove that to be able to suggest that somehow you're complicit in an individual who's been released, because this is what the senator's trying to get after. An individual that should have been held, that should have been removed from this country because they're violent. There's plenty of examples of it. Being released by that jurisdiction because they have said, boldly, like they were doing before 1105, we're not going to do this. And then someone is assaulted or killed or murdered or raped. And so they now have been aggrieved because of the just intractable, stubborn desire of local governments to avoid what are state laws. That is what the senator's trying to get at. So I think you're obfuscating it to some degree to talk about all these things. It's pretty clear you're either a sanctuary jurisdiction or you aren't. If you're doing those things that we expect everybody to do, there's no worries. There's no worries. And yes, an ICE hold is a 48-hour hold. The feds are never going to accept that there's probable cause to hold someone longer than 48 hours for ICE. And I accept that. So, and if ICE wants them, to my good friend here's point, they should come and get them. Mm-hmm. What's happening today across this country is they're coming to get them. But they weren't before because other administrations did not want to remove even those criminally in this country. Shame on them for it, and shame on local jurisdictions for abetting them in that process. Shame on them. The senator's trying to stop that, as we did last year.
Thank you, sir. Follow up. Okay, go ahead.
Just confirming, so the only intent is for those that refuse to hold 48 hours or less, correct, Petrie?
48 hours.
Or less. Anybody that does not hit the 48. Okay, it's clear. I'm good.
It's been tested in the courts, thoroughly tested.
All right. Looks
Thank you,
like
Mr.
you're
Chairman.
off the hook. Thank you. All right. We have a few more folks that want to speak. related to this bill. Kyle? Hey, you want to go to the podium there? Sorry, I didn't pronounce your...
No, it's all right.
I got half of your last name, the Gomez part.
Gomez is easy. Lineweber gets a little complicated.
That it did. So, all right, sir, go ahead.
Thank you, Chairman. My name is Kyle Gomez Lineweber. I'm the Director of Policy and Advocacy with the Galileo Impact Fund. We seek to civically engage the Latino community. There are more than close to 5 million Latino voters in the state of Georgia, and we also seek to advocate in our community's interests. We speak in opposition to SB 21. We feel that SB 21 is, at best, is redundant, and at worst is incredibly harmful to our communities. HB 1105, which passed last session, it's already been discussed some, seeks to withhold funds from local officials and local entities that don't comply with ICE detainer requests, even though federal courts have ruled numerous times that those detainer requests are just that, requests, not mandatory. And then, of course, Georgia Code, Chapter 36, Title 80, and Section 23 also seeks to withhold funds from local governments enacting quote-unquote sanctuary policies. As has been discussed, throughout this hearing, sanctuary policies are broadly defined by this code section, and that's an issue. But SB 21 goes a step further. It doesn't just take funding. Wouldn't just take funding away, but it would actually drain local taxpayer dollars to defend against potentially frivolous lawsuits, which is a particular concern, again, when we consider how broad sanctuary policy is defined. SB 21 offers no resources, insights, or analyses as to the cost of this legislation, which is especially relevant, again, given the passage of 1105 and the fact that we know that local governments in Georgia lost close to $90 million between 2008 and 2018 just to comply with ICE detainer requests. Other concerns that we have are around, we know that, for example, the Chamber of Commerce has told us that we are going to face a workforce shortage crisis by 2030. In the state of Florida, when we saw SB 168 passed into law, there were major effects on numerous industries from tourism, agriculture, to construction, which are all important industries here in the state of Georgia, which we know that immigrants are the base and foundation of for those industries. And then, of course, we have concerns around public safety. When the state of Texas passed SB 4, there were numerous studies that showed that there was a direct relation to the passage and implementation of SB 4 and an underreporting of crimes in the state of Texas, and we would hate to see that happen here in the state of Georgia. And then, of course, we have concerns about the long-held principles of home rule and usurping the authority of local voters and their will, and their local officials implementing their will. And then I would just make one final point that I wasn't going to bring up, but it was brought up earlier. Someone mentioned that there were 1,700 violent felons, immigrant felons in the state of Georgia. That number is off by about 1,600. So that is incorrect, and there are numerous, we disagree. I disagree there, sir. And there are numerous studies that show that immigrants, undocumented or otherwise, are about a third as likely to commit any crime when compared to citizens. So, thank you.
Yes, sir, you may.
Sir, you're giving misinformation. Everybody on this body in the House last year, every year I put on their desk from the Department of Corrections the list of all ICE detainers and the crimes committed by those individuals. And it fluctuates between 1,600 to 1,700 every year. So everybody in this body has reviewed it, even lately. You don't know what you're talking about. Thank you for being here today.
All right, Chairman Sains.
Thank you, Mr. Chairman. And just to be clear, I think you did state it at the beginning, but you're with the Georgia Association of Latino Elected Officials?
I'm with the Galileo Impact Fund.
Okay, is that associated with the?
It's a C4 organization. The Galeo, which you're talking about, is this 501c.
Okay, sorry, and I understand the distinctions.
Yeah, I just want to make that clear.
So, in understanding the correlation of opinions coming from a different source, is it Galeo or Galeo Impact's opinion that fully enforcing our state and federal illegal immigration laws better serve the Latino community, which I'm a part of, that are a vibrant part of this state? Is it your organization's position, just when we talk about the baseline of what we're trying to do, that it better serves all Georgians, Latino Georgians who are here with full authorization of the law? Is that a policy position that we're in agreement of, or is that a distinction?
Oh, are you asking?
Does it better serve Georgia and the Latino community by fully enforcing our state and federal immigration laws?
I mean, we certainly don't advocate for, the breaking of law, and as I mentioned before, there is numerous studies that show that immigrants, undocumented and otherwise, are a third as likely to commit crimes as U.S. citizens, and are led through our Puente para la Gente survey, which we conducted, and numerous other resources that we have. Our community, the Latino community of registered Latino voters in the state of Georgia, have a nuanced view when it comes to immigration. Yes, we want to, protect our national security interests, in Georgia and the United States. No one's pushing or advocating for anything against that, but we also want to see comprehensive immigration reform that keeps families together and preserves the economic success in a state that likes to claim to be the #1 state to do business in.
Real quick, because I know we're short on time, if that's okay, Mr. Chairman.
Yes.
I want to make sure for everyone listening at home or what the intent is here, because I think we're in agreement. The Latino community in Georgia is a vibrant one. It adds to our state economy. I'm undocumented right now. I don't have my license with me. What we're talking about here is not undocumented immigrants. We're talking about those who violated our immigration laws, those which we have no record of their safety or non-safety, their authorization or non-authorization to be here. Those, we're just ensuring that our local governments are fully enforcing those federal laws and those restrictions to ensure our communities are safe, both the Latino community and non-Latino community. And that's what I'm still not getting a clarification if that's the intent of the organization or not, because there can be a lot of rationale given to this policy, but if that's not an agreement, which is perfectly acceptable not to be, I think that carries some influence to what we're hearing here.
Well, I think we're asking the question, is a good use of public taxpayer dollars to paint communities with a broad brushstroke and raid whole neighborhoods, whole communities, whole businesses, disrupt local economies, and make our families, especially those, there are a lot of mixed status families in the state of Georgia, disrupt their lives, disrupt those communities. And again, we know that the effects of that, regardless of how you feel about undocumented immigrants and their right to exist in the United States, but we know that these types of activities lead to an underreporting of crime when individuals who are experiencing abuse, who are being abused, who are witnessing abuse or crime, when the first question that comes into mind has to do with immigration status, that can be the defining prevention of someone reaching out to law enforcement to get the help that they deserve.
All right, Representative Ridley.
I have a question after what you just said. You said that these illegal immigrants are less likely to commit a crime, but now you're saying they're not going to report crime because they're illegal. So they're not going to report violence. So
I'm talking about specifically victims of crimes.
So,
people who are experiencing abuse and then are afraid to call law enforcement to get the help that they need because they're worried that they're going to be put into an ICE detainer when they're being abused by someone else in the home.
Well, if they didn't break the law in the first place by coming here illegally, that wouldn't be happening.
Well, I know that that's your feeling, but I mean...
Well, that's the feeling of administration and the majority of voters.
All right. Any more questions for this gentleman? All right, I don't see any. Thank you. Rosario Palacios? That might have been close. I may have gotten really close with that one.
That was great. That's how I would say it.
All right. Thank you.
Thank y'all. I apologize if you can't see me well behind this podium. But Mr. Chairman and members of the committee, my name is Rosario Palacios, and I serve as the Executive Director of Common Cause Georgia. We're one of the oldest nonpartisan government transparency and accountability organizations in our state. I was proudly raised in Gainesville, Georgia, the poultry capital of the world, although Nebraska, I think, beat us out some time ago. And I'm also the proud mother of 4 children in the North Gwinnett public school system. Thank you for the opportunity to speak today. I want to be here to oppose Senate Bill 21 LC 570224S. This bill, which targets so-called sanctuary policies, gravely threatens government accountability and community trust in Georgia. It would punish our local governments, even school boards that are special purpose local government, and law enforcement agencies for exercising discretion and judgment and serving their communities. SB 21 undermines the very principles of local accountability and public safety that it seeks to protect, and it also does so at an enormous economic and social impact cost to our state. I urge you to not advance this dangerous bill further than it already has been. By stripping sovereign immunity from local governments that are perceived as not aggressively enforcing federal immigration law, this bill invites a flood of frivolous lawsuits against cities, counties, school officials, and police. We don't really have to guess what the impact of this heavy-handed state immigration enforcement would be. Georgia's own recent history offers its own cautionary tale. In 2011, our legislature passed HB 87, a strict immigration law similar in spirit to SB 21, and the results were devastating to Georgia's economy. As someone who was raised in Georgia, I have friends and neighbors, some of which owned Oeste Western Wear, the best place you could get your cowboy boots and cowboy hats, and they actually moved out of the state. They moved to Delaware, and the father for some time had to commute back and forth on the weekends to see his kids. This is something we've seen before, the message that it sends and the real life social impact and economic impact to our state. According to the Georgia Fruit and Vegetable Growers Association, about 40% of Georgia's fruit and vegetable crop was left unharvested due to labor shortages, which cost an estimated $180 million in direct farm losses and $340 million hit to the Georgia's economy. I've already spoken about the beautiful budding poultry industry that is in Northeast Georgia that I got to work in out of high school, and that my parents came to the state to be able to work in after being migrant farm workers for a while. Beyond economies, I really want y'all to consider the social and public safety costs of measures like SB 21. When states like this go too far, they do instill fear in immigrant communities. We have already seen that this year. I have seen for several Mondays in a row children missing school in the Hall County, Gwinnett County school districts where I am close to, out of fear that ICE is going to show up to their school. Parents have also fed into some unfortunate anti-disinformation, although under the current stress of ICE, we do stand to wonder if that will ever be a thing. We don't have to look further. Even in Alabama, their own law that took effect this past decade, they've also seen students impacted by anti-immigrant legislation. And so when we are here discussing SB 21, I really want us to think about a lot of that real life impact. I myself am a survivor of domestic violence. I myself have been through the journey of an immigration process. I'm a naturalized citizen. I remember being out of status, and I do remember suffering at the abuse of a citizen who threatened to use immigration laws against me. And so I say all this, I share a little bit about my story and the thoughts and the stance of our organization, because I really think that this threatens our values of inclusion and fairness. I think there's going to be a profound economic risk that we already have precedents for. And so on behalf of Common Cause Georgia and many concerned citizens across our state, I really urge you to halt SB 21 in this committee. I think that this committee cares about public safety. I know that we have a shared value of that, and that public safety comes from trust, it comes from cooperation, it comes from needing folks to be able to come out of the shadows, engage in their local government, and for there also to be accountability when things have gone wrong. And so I respectfully ask this committee to reject SB 21. I don't want this misguided policy move to further risk our economy, our workforce, and our safety. Thank you. I stand.
Chairman
for those
Sainz?
questions.
I'll be quick, but you brought up something that has already been brought up, that instilling fear in our immigrant community. And I think part of that blame, I'm sorry to say, is the utilization of words that water down what we're talking about. When we say undocumented, someone at home, I fear, would again, I'd make light of it, not having your record or not having your license plate. So yes, what it makes sense when we're talking about this, and there's words like that thrown in, that we're doing unnecessary damage to immigrants' community. So to make sure we're in the same page, we're talking about enforcing our immigration laws. Is that correct?
I'm talking about public safety. I think federal immigration laws are being already enforced on a federal level, and I think a lot of the folks who wanted to intend a different impact would agree with the current federal government's approach to federal immigration laws.
Federal immigration law, for simplicity, is applicable. Illegal immigration enforcement is applicable to an individual who does not have a legally authorized point of entry or has overstayed a temporary visitation of visa. Is that correct? So if you're not an individual in the state of Georgia, if you're not a Latino or any other immigrant in the state of Georgia that does not apply to, this has no effect on you. Would that not be correct?
I would disagree. In Georgia, the degree of separation, especially with immigrant communities, is is less than in other states, right? Where you can see maybe Latino descendants in California and Texas and some of the border states. In Georgia, the Latino immigrant came here, right, because of the booming workforce 30 plus years ago. There was really a spike. And so here, even persons like myself who are U.S. citizens, right, the degree of separation of someone who is out of status, out of an immigration status that you referred to, is actually much less than in different parts of the country.
So you're speaking of knowledge, and look, thank you for going through the naturalization process. As a son of a mother who's gone through the process, of a younger brother from a sister who's done that process, that degree of separation is not correlated to what we're talking about. We're talking about individuals who are not here with legal authorization. And I want to make sure for both the organizations who I think are meaning to do benefits to these communities, but might unintentionally be doing harm by instilling unnecessary, unreasonable, and unlogical fear. We're not talking about citizens in the state of Georgia, Hispanics or immigrants of any kind. We're talking about fully enforcing our state and federal immigration laws.
Thank you. I hear you.
Okay, thank you. And I don't see any other questions. I do want to, first, I want to commend you for being a survivor of domestic violence. But I also want to caution you, as Chairman Sainz said, words matter. And you up there several times referred to this as anti-immigration legislation. There's nothing anti-immigration or anti-immigrant about this legislation. I don't think there's anybody here that is against legal, lawful immigration. We were all immigrants at some point. But to use those words, when you use words like that, they call it anti-immigration legislation. I think it distorts what we're trying to do, and it places fear on more people that shouldn't be fearful because of the words that you use. So I would appreciate that we talk about it openly and honestly and call it what it is, okay?
I hear you.
Thank you.
Thank you. Yes, I just named the social impact to immigrants, which is severe and disproportional than any other population, but I hear you on semantics.
Yep, thank you.
Have a great day.
You too. Brian Ramirez.
Good afternoon, Chairman and members of the committee. My name is Brian Ramirez. I'm the Advocacy Manager for the Georgia Youth Justice Coalition for Action and a student at Georgia State University and a proud naturalized citizen of the United States. But that was not always the case. I was born in Colombia and came to this country as an undocumented immigrant. My family came here searching for a better life, one rooted in the values of freedom, opportunity, and hard work that the United States embodies. My parents worked tirelessly for little to no money, doing the jobs that kept Georgia running. Yet, despite every obstacle, they built a life here, and now they are proud parents of a hopefully soon-to-be graduate of Georgia State, myself, and my sister, who graduated from University of Georgia 10 years ago. We are proof that when given the chance, immigrant families don't just survive, they thrive. But let's talk about what SB 21 really does. It's not about making our community safer. It's about targeting people like my family, families who came here seeking opportunity, but instead are met with fear and criminalization. This bill further forces local governments to cooperate with immigration detainers. It strips communities of their right to make decisions about how they protect and serve their own residents. It could deplete local governments of funding due to lawsuits when these laws are already mandated by HB 1105, and it's a dangerous attempt to turn local officials into federal immigration agents, increasing wrongful detentions and the separation of families. My biggest concern is that the definition of local governing bodies in this bill includes local school districts. Schools should not be a place of learning, or schools should be a place of learning and safety, not sites of immigration enforcement. ICE detainers should never include young children, children who have done nothing wrong, children who came here with their families seeking a better life, just like I did. And look at me. Do I look like a criminal to you? I pay taxes, I pay bills, I contribute to my community, just like every person in this room. Even my parents, who worked 80 hours a week for little to no pay, also pay taxes, even though we never received any of the benefits. We have dreams, just like you. This bill would make life even harder for people who are simply trying to exist. Bills like SB 2021 and HB 1105 make parents afraid to drive their kids to school, workers afraid to report unsafe conditions, and students afraid to reach their futures. We should be building a Georgia that welcomes hard work and hope, not one that punishes it. I urge this committee to reject SB 21. Let's focus on policies that uplift all Georgians, not ones that tear families apart. Thank you.
Thank you. I don't see any questions from the committee. Anybody in the committee got anything further? Senator Tillery, do you have anything else you wanted to add before we wrap up? Okay. One thing I did want to mention, but I'm not. Never mind. Change my mind. We'll save that for next time. It's been a long enough day already. So we will have you back soon. I know I talked with ACCG and GMA on some of these amendments. I've had a chance to look at it. The committee's had it, they've got copies now. They'll look at it. We'll see if there's anything that they want to do about that, and we'll be back in touch with you soon. Thank you. And with that, seeing no more business, we will stand adjourned. Thank y'all.